Morning, Joel sir. With your permission, should we begin with the introductions and the rest of the lecture?
Yes.
Sure. So, welcome everyone to the second session of the certificate course on space and aviation laws. For today, we have Dr. Joel Lisk as our speaker. Sir is a lecturer in space law at Flinders University's College of Business, Government and Law, where his research focuses on how domestic laws shape private and commercial activities in emerging domains like outer space. He holds a PhD in law from the University of Adelaide, where his thesis explored Australia's space legislation and its reform. A qualified lawyer, Joel has advised clients across heavily regulated sectors, including space, aviation, consumer protection, and data privacy. He is also the company secretary of the Space Law Council of Australia and New Zealand and has presented widely on compliance and regulatory burdens in the space industry. With both academic and practical experience, Sir continues to bridge the gap between legal theory and commercial regulatory needs in the rapidly evolving space ecosystem. So, thank you so much, Sir, for joining us today. And over to you for today's lecture.
Great. Thank you for the introduction, and thank you for inviting me to present as part of this series. It's an amazing list of speakers you've got over, I think, starting from yesterday over the next couple of weeks. So I hope everyone's looking forward to it. I will just start to share my presentation for you all. Entire screen. So thank you once again for attending, everyone. As I've said, my name is Joel Lisk. I'm a lecturer at Flinders University, and I'm lucky enough to have the title a lecturer in space law. So today I'm going to be talking to you a little bit about environmental protection and sustainability from an outer space perspective. And so I'll dive into some of the law, some of the legal levers we have in place, and a few of the other kind of incidental matters that relate to how we manage environment and environmental protection in the space domain. I'm speaking to you from Adelaide in South Australia. So if you're not familiar with where that is, it's right bang in the middle of Australia down the bottom. And I said that because I picked this picture here on the screen for a really important reason. So Adelaide is effectively the hub of space activities in Australia. And this picture here is actually a track of the W2 capsule that was returned to Earth from space in March of this year. And it marked the first time a privately owned capsule returned to a privately operated spaceport anywhere in the world. So this capsule was launched in the US and returned in March, and it was followed by another one a few months later. Why is that important? Well, it actually represents the combination of lots of different laws and the interaction of different laws. And environmental protection laws were actually a really important part of that process. So it shows that we might be doing fun and awesome space activities, but there is a really important interaction with everyday laws and environmental protection as well. So today I intend on covering a lot of different things, hopefully not take too much of your Sunday morning for where most of you might be. So I'll cover off a bit about what environment and sustainability are as concepts. I'll touch on some of the applicable sources of law, being international law, domestic law, as well as some non-binding materials, and then touch on some of the key challenges that interact with environment sustainability from the space perspective. So talking about space debris, overcrowding in orbits, light pollution, atmospheric pollution, and the risks of interplanetary contamination. So when we think about environment and sustainability, they're very contextual concepts and terms, and the definitions and the concepts will actually vary quite significantly between the different contexts. So we talk about the environment from an Earth perspective. We're generally thinking about the areas that surround us, the natural environments, and the areas in which we occupy as humanity. And then when we think about sustainability, we tend to think about the protection of that environment, the need to continually ensure its access and its enduring nature. And so that's very much a terrestrial concept. So how we're thinking about environment and protections is very much dependent on the context. So when we think about it, we're going to think about it from a space perspective, though. So we're going to move away from the physical environment that we have here on Earth and look into space a little bit more. So firstly, I wanted to touch on the idea of the environment. And in the context of this presentation, the environment will generally be considered as the physical space, that is the outer space environment, effectively everything that's not here on Earth. It's the place in which our planet occupies. It's slightly strange to sometimes think about these things as not being our planet, but when we have a very Earth-centric approach to how we look out, it tends to be slightly strange to think of the environment as everything but Earth, but that's what we'll intend on doing a bit today. I will also talk a little bit though about the environment of the Earth, which is impacted by space activities. So some of the things we do in outer space, of course, impacts us down here on the ground, and impacts our natural and physical environment here on the ground as well. The same can be said for sustainability. So in the context of this presentation, I'll be talking a little bit about the idea of sustainability of activities in outer space. So that's whether they're commercial activities, commercial activities, governmental activities, military activities. But thinking about their sustainability from a commercial, operational, financial, environmental, or even existential perspective. And so in this sense, I'm not talking about sustainability as if it's environmental sustainability. I'm not talking about sustainability as if it's about protecting the environment just to itself. We're actually talking about the sustainability of activities, effectively the conditions that allow activities to continue in an enduring way. We'll also talk a little bit though about maintaining the space domain as a resource and region that all can explore and use sustainably into the future. So in this context, I just want to draw really quickly on the United Nations Sustainable Development Goals. And in that context, sustainability is actually described as the ability to make development sustainable to ensure that it meets the needs of the present without compromising the ability for future generations to meet their own needs. Now, that definition was created in 1987, so quite a while ago now. But the idea there is that as humanity, we move forward and we continue to do new and interesting things. We do need to be thinking about how those new and interesting things can continue, whether they should continue, and the conditions that we set as a species to how those activities continue into the future and the impacts they might have. For the space context, though, I'll be looking more to long-term sustainability, and this definition, which I'll talk a little bit more about later, was developed in 2021. And the idea is it's the ability to maintain the conduct of space activities indefinitely into the future in a manner that realizes the objectives of equitable access to the benefits of the exploration and use of outer space for peaceful purposes in order to meet the needs of the present generations while preserving the outer space environment for future generations. So you might see some degree of similarity between that 1987 definition and the one that was developed about 40 years later. So what are the challenges when we talk about the environment and sustainability related to space? Well, the uses of outer space are rapidly increasing. And I don't think that's relatively new concept to many of the people who will be on this call today. So increasing space activities are not necessarily a bad thing. We don't necessarily need to say, just because space is popular, we need to stop. Space is really popular because of the consequences of the activities that we use it for. So when we think about the space domain and the space industry broadly, the benefits are significant. We're increasing connectivity, we're increasing communications capability, which therefore facilitates increased education and effectively can improve the outcomes and the lives of millions to billions of people through using space-enabled and space-facilitated technologies. Of course, as well, it's very important in this context to think about the commercial imperative, as commercial actors are generally leading the way when it comes to space now, and that there is a capacity to derive profit. And profit is important because it justifies the existence of an activity in some respects. Now, this graph here is taken from the European Space Agency's annual environmental and debris assessment report. As you can see, the evolution of the number of objects in all orbits is rapidly increasing. And it's significantly increasing in recent years, effectively as a consequence of the introduction of mega constellations. So we can see the rapid push, particularly just around the beginning of COVID, so 2019, 2020, and what that's effectively seen on the total number of objects in outer space, which is sitting close to 40,000 now in operational orbits. So what does that mean? And what does that lead to? Well, effectively, it leads to challenges, and it leads to problems that we need to address from a sustainability and an environment perspective. Increasing uses of outer space means there's increasing numbers of defunct payloads, rocket bodies, the fragments of both of those, and other identifiable objects in outer space. So space debris. There's increasing congestion in highly valuable orbital regions, which effectively leads to overcrowding. We're seeing emerging concepts impacting people on the ground, things such as light pollution. There are increasing numbers of space debris and spacecraft re-entering the atmosphere on a regular basis now, and that can lead to atmospheric pollution. And with us looking as a species further and further and deeper into space, particularly in the with the push from some areas to look at establishing settlements on different planets and celestial bodies, there's also the risk of interplanetary pollution from missions going beyond Earth. So what are we as a species taking further into outer space? Importantly, the law doesn't necessarily have all of the answers. It has a few answers, it has a few levers, and it has some potential solutions and ways of responding to these challenges. And these are the kind of the things I'll talk about for the remainder of this session. Now, there are several legal tools available. I've broadly and somewhat arbitrarily grouped them into three categories. There's international law, so we have outer space specific laws, and we have general international law. There's domestic law, so national laws that exist within countries that they've created for themselves that relate to space activities, as well as any other law that could possibly apply to space activities. Just because something's happening in space doesn't mean it's essentially overly special. We'll also talk about, very briefly, talk about thresholds to market access. So the laws that exist that effectively force other operators to do certain things in order to access new customers. We'll talk about non-binding instruments and approaches as well. So these are non-legally legislative approaches. Of course, we'll talk about standards and industry standards and what they might mean. Political agreements and arrangements, guidelines and recommendations, concept of what a social license for activities are, as well as private law, so contracts and arrangements between different parties. So the first thing I want to start off with is international space law. Now, I understand you had a session yesterday with Professor Batt, and I will not try to recover any of that ground because he's a very much an eminent professor in that field, and I think I would pale in comparison to the summary he gave you probably yesterday. But I'll touch on these very, very quickly because they provide a really important background for how we approach space from an international perspective. So we have 5 space-specific international treaty instruments. We have the 1967 Outer Space Treaty, which is the primary one I'll talk about today. But we also have the 1986 Rescue and Return Agreement, the 1972 Liability Convention, the 1975 Registration Convention, and the 1984 Moon Agreement. These 4 treaties together form kind of a specialist approach to space activities and specialist approach to outer space. What does it actually mean, though? Well, it means we have a subset of laws that can potentially be useful for us. So starting with the Outer Space Treaty, importantly to say that the Outer Space Treaty is a treaty of principles, which means it doesn't necessarily have all the answers. It has the starting point to some answers, and it has the tools and the mechanisms that we can think about using in new and different contexts to address emerging problems. So on the face of the document, it might not have all the answers, but it doesn't necessarily need to, because that's not the role of this particular instrument. So in thinking about the environment and sustainability, I've drawn out these 5 provisions and try to emphasize how they can potentially be important. So the first one is Article 1. This particular section is the exploration and the use of outer space shall be carried out for the benefit and interests of all countries. The idea there, and particularly in this context, is that if we don't think about the environment and we're not thinking about sustainability, how can we ensure that the domain that is outer space is accessible to everyone now and into the future? If we don't treat it with respect and we're not thinking about the consequences of our actions, can states generally be said to be thinking about the interests of all countries? They might be thinking about it at a single point in time, but they might not be thinking about it into the future. Article 3 of the Outer Space Treaty effectively incorporates all existing international law generally and ensures it applies to outer space. I'll touch on this in a moment, but it's really important because that means that all the law we have, every bit of international instrument, can apply to the space domain and apply to the space context. And it's important to remember that as humanity, we create the laws that apply to us, and then we take them with us into the space domain. Article 6 of the Outer Space Treaty is a somewhat contentious provision if you talk to different people, but broadly for today's purposes, it assigns this idea of responsibility for non-governmental entities to a state. Why is that important for sustainability in the environment? Well, it creates an obligation and it creates a risk. If non-governmental entities of a country are allowed to do whatever they might in outer space, that creates a risk for the country to be responsible for the actions of those entities, irrespective of how that's happening. And that's the same for liability as well. That creates a financial pressure and a financial risk. If you're not complying with the law and you're not respecting the domain, there's a risk there to the state that they might incur costs they didn't otherwise want to incur. Article 9, though, is generally latched onto as the most important provision related to environmental protection and sustainability in the space domain. So this first part I've got extracted on the screen here is about the principle of cooperation and mutual assistance, and the idea that activities should be conducted with due regard to the corresponding interests of all other state parties. That effectively means that states should think about the activities they're doing and think about the actions and consequences of those activities and the impact they might have on others. Importantly, it doesn't say that states must act with due regard or must have due regard and consequently must stop an activity or must cease an activity. It's more an obligation of respect for another, but it doesn't necessarily stop a state from doing something that might harm another, which is always an interesting distinction to make. The second sentence I have extracted there on the slide is that state parties to the treaty shall pursue the studies of outer space and conduct exploration of them so as to avoid harmful contamination and also adverse changes in the environment of Earth arising from the introduction of extraterrestrial matter, and where necessary shall adopt appropriate measures for this purpose. This one's quite interesting because it actually is about environmental protection of the Earth. It's not about protection of outer space. If we think back to when we created the Outer Space Treaty, it was the 60s, and the declaration that led to the Outer Space Treaty was developed in the late 50s. At the time, we didn't know very much about outer space. We didn't know much about the lack of biology. We didn't know much about the depths of the domain. There's a book that was co-authored by Philip Jessup that's very interesting, talking about the law of outer space and talks about the law of Antarctica, but it was written in the 50s. And there are sections of that book that refer to the possibility of Mars being covered in plant life or bacterial life. Of course, today we know that's not true. But when we think back to the time when these instruments were created, there was the risk and the perception of risk that if we did things in outer space and brought them back to Earth, that they could cause significant and harmful contamination to the Earth. So that's an important provision to think about, and important to think about in its context and how it's situated within the provisions of the treaty. So turning to the other three agreements here, and then the Moon Agreement on the next slide. Of course, these treaties are more specific. They're not as broad, they're not as guiding, and they cover off a few very particular ideas. I've drawn out these several points here as not necessarily being central to the protection of the environment, but more being about provisions that can trigger thinking and trigger potential consequences if thinking hasn't occurred from an environmental and sustainability perspective. So with respect to the Rescue and Return Agreement, of course, it does cover the return of objects that have come back to Earth. So do you have to return them to the state of registration? Yes. What are the consequences of that if you don't do it properly? Are there costs that can be incurred as part of that process? They're all important to think about. The Liability Convention, of course, as I said earlier, creates a quasi-price signal on conduct in outer space. If activities are not conducted with regard to others, if states deliberately or otherwise impact on other states and cause damage to those other states as a result of activities that weren't considering environment or sustainability perspectives, there is a potential for financial consequences. And price signaling conduct, particularly in today's society and global environment, is quite important, and it's a way of encouraging good behaviour through the elimination and the reduction of risk. The registration and convention, of course, is not necessarily about assigning risk or apportioning risk, but it's there to allow for attribution of conduct through registration and the confirmation of jurisdiction. So someone is in control and someone is and has jurisdiction over activities, and that's always important to remember. Now, I'm always scared to use the Moon Agreement as an example of anything. It reflects many of the principles contained in the Outer Space Treaty. It was negotiated with most of the key space parties at the time, the spacefaring states, but it's not very well adopted. At the moment, at the beginning of the year, it had 17 full parties and 4 signatories, which is significantly lower than the Outer Space Agreement, which had Outer Space Treaty, which has 116 signatories as to the beginning of this year, and an additional 23 signatories onto that as well. So it's not a well-accepted agreement, and some states, particularly the United States, have persistently objected to the Moon Agreement being treated as anything more than just an agreement between several parties. But what the Moon Agreement does is it expands on the content of the Outer Space Treaty, and it kind of picks up on a few key themes and principles about how we should be looking to the treatment of other celestial bodies. So here we have in Article 4.1 that due regard should be paid to the interests of present and future generations, as well as to the need to promote higher standards of living and conditions of economic and social progress and development in accordance with the Charter of the United Nations. It's quite a lofty provision. It's not one that will necessarily have much binding force because of its ambiguous and kind of aspirational nature. But it's important to note that that provision is not in the preamble. It is in the provisions of the actual treaty. Therefore, theoretically, it is binding. And the idea behind it is very clear. It's thinking about today, and it's thinking about the future, and it's thinking about ensuring space is available to everyone into the future. Article 7.1 is similar, and it requires that state parties take measures to prevent the disruption of the existing balance of the environment on celestial bodies. So that might be the moon, or it might be elsewhere. And so that provision is the opposite of what's contained in the Outer Space Treaty. It's there to protect the celestial bodies that exist. So the Moon Agreement, unlike the Outer Space Treaty, does contain more specific and more targeted standards that actually apply to the conduct of these on these bodies. But beyond outer space, as I said, all other international law still applies to the maximum extent possible. So that could be anything. And when we think about environment and sustainability, we think about the principles we have in international law at present. So we have the idea of the no harm principle, that prohibition on transboundary harm, that states shouldn't conduct activities within their jurisdiction that negatively impact on another, and that theoretically that could extend into the space domain. So the activities of one state in space should not negatively impact on the activities of another merely because they're nearby or merely because they're close. Of course, there are underlying protections of the sovereignty of states, so interfering with the sovereignty of other states will never be willingly accepted. There are specific treaty instruments less likely to have an immediate impact, of course. For example, I'm just thinking of immigration-related treaties or aviation-related treaties will not necessarily apply in outer space, but principles and concepts may follow with them. But a very important treaty framework in the international space sector is the telecommunications framework, and that exists under the International Telecommunications Union. The regulation of radio communications and spectrum is incredibly important to the long-term sustainability of the space domain, because of course, if you can't communicate with your satellite, then there's no point that satellite being there, and it is effectively debris. And if there weren't laws to regulate how spectrum was used and how communications with those satellites were used at the international level, we would not have a space sector today. So it's a very important framework, and one that is a very highly specialized area to be dealing with. But now I'll take a step down. So looking into now what states are doing themselves. So as we all probably are aware, every state has the right to legislate and to govern affairs within its own jurisdiction. From a jurisdictional perspective, sometimes these domestic laws will cover territorial and national jurisdiction. So the idea that a state can legislate for the activities within its territorial jurisdiction, but also for the activities of those who have its nationality. For example, as an Australian, if I was to launch a space object anywhere in the world, I would be required to comply with Australia's law for space activities. That is purely because I hold an Australian passport. And most countries around the world have taken similar approaches to the space sector. They've gone, well, we have laws that apply in our territory, but we'll also have laws that will apply to our nationals anywhere they are in the world in the context of outer space. Beyond that, it's not something we see too much of is protective and universal jurisdiction. They're more relevant for international criminal law and in that context. But when it comes to domestic law for space activities, there is an important consequence of the international framework. Article 6 requires states to authorise and continually supervise the activities of non-governmental entities, and the general response to authorisation and supervision has been to enact some form of legal instrument within a jurisdiction that does exactly that. Of course, national laws are very hard to generalise. They serve a specific national or policy-based goal. They reflect the characteristics of individual legal systems, and they vary quite significantly in their nature and form. We can talk about laws, for example, in the United States, which has a very, very highly evolved framework of domestic law for space activities, as you might expect, to facilitate effectively launches happening every 3 or 4 days. Compare that to a country such as Norway, which was actually the first to introduce laws for launch activities. That entire law is 3 sections long. So we have hundreds of pages in the US and 3 sections in Norway, both theoretically achieve the same goal: to regulate the activities of entities within their jurisdiction wanting to launch things. But generally, national legislation for space is largely focused on non-governmental entities. It's broadly there to regulate launch, return, and the operation of space objects. And it's principally focused on protecting the state, though. It's about public health and safety and financial liability. The environment and sustainability are not key concepts. They're not primary thresholds generally. They're not preconditions to the grant of licenses in a lot of circumstances. But in an increasing number of frameworks, debris mitigation and some consideration for the space environment is becoming more and more important. Why? Because we are now aware as a global society of the issues regarding the environment. This is just a quick slide to show this is not every law that exists within jurisdictions that apply to space activities, but it's to demonstrate that there has been a progressive growth. Over time, the number of countries that have enacted laws related to space activities has increased quite rapidly. And as you can see, that tends to bunch up a bit closer there to the end of the graph. But there are a lot of laws that apply to space activities, and a lot of them are jurisdiction dependent. And it feels like every maybe 6 months or so, there's probably another 3 or 4 countries that can be added to this list. So what about more general laws though? So of course, there are a lot of laws within our countries that will regulate the activities of non-governmental entities, myself, other corporations, and a lot of those laws will impact the activities we're doing irrespective of where they're happening. A lot of them are behavioral based, so criminal laws on the ground. If I'm not going to be allowed to fly my satellite directly into someone else's satellite, that will probably violate a lot of different laws in a lot of different countries. But generalist laws will apply, and they do have consequences. So corporations laws apply to businesses who are carrying out space activities. Just because you operate a satellite in space doesn't mean you're now in space for taxation purposes. Your tax regulators will find you. Consumer laws may apply to your activities irrespective of where you are. National security legislation as well. And importantly, and when I should have made sure I dot point on this slide, was that environmental laws will apply. So in a lot of jurisdictions here in Australia, the United States, the United Kingdom, throughout Europe, the national legislations related to space activities will generally say that a non-governmental entity seeking a license must be in compliance with all other law that applies, including environmental and planning laws for their launch facilities. So if you need to launch something like this rocket here on the slide, there will need to be an environmental approval in place for the ground, and it will need to have been considered. Of course, thinking back to the beginning of this lecture, we were talking about the environment as the space environment. So that's not something that's actively considered, though, in many of these frameworks. Market access regulation is a bit of an interesting area because it's about the consequences of territorial jurisdictions. So if I was operating a satellite constellation and I wanted to provide a service into a different country, that country will likely require me to comply with their laws before I'm allowed to provide services to their population. And what this can mean is you end up having to comply with new and different laws merely because of market access requirements. The EU is an amazing example of this and is very good at creating laws that require businesses to tick off on certain matters before they're allowed to access the jurisdiction. And really good examples of that include things like the Digital Markets Act and data protections like the General Data Protection Regulation from about 5 or 6 years ago, which require businesses all over the world to adapt their standards to the European Union's purely so you can access that population. So if you're operating a satellite constellation and wanted to access that very large market, there is a risk that you'll have to comply with EU standards. And that's becoming even more important now after the introduction of a draft bill through the European Union in the last couple of weeks that does relate to space activities. So beyond that, I want to talk a little bit more about non-legislative tools. So what other things are out there that can relate to behaviours around environment and sustainability? So we have the idea of industry standards and standards generally, political agreements and arrangements, guidelines and recommendations, this broad concept of social license and its associated concepts, and then private law, so contracts between parties. These are all less than legislation, but they are all socially or otherwise enforced. They're non-self-executing, they have no coercive power in and of themselves. So just merely breaching these arrangements will not immediately lead to arrest. It won't lead to a government taking action, but they're there to create a barrier, to create a requirement. But they're generally more flexible and adaptable. They're responsive to immediate concerns and issues, but there's still that limited mandatory capacity. So I now touch on each in turn. So industry standards and standards more generally are effectively codifications of practices that businesses are taking that are effectively treated as the gold standard or what all businesses should be doing. They can be developed through an intergovernmental arrangement, such as the International Standards Organization. They could be led by governments, or they can even be industry-led. And there are a lot of them related to the space sector, particularly on operational requirements, so how your technology speaks to different pieces of technology. But space debris is also another area where there is a lot of different standards. For example, we have the Interagency Space Debris Coordination Committee that releases its space debris mitigation guidelines and updates them quite regularly. So we're up to revision 4 now, which was released at the beginning of this year. We have the Space Debris Mitigation Guidelines from the United Nations Committee on the Peaceful Uses of Outer Space that were released in 2007. We have the International Standards Organization, which has a lot of different standards. Unfortunately, I couldn't list them all on the page, but they all relate to different systems and different subsets of systems. So I have 2 here. I have the Space Systems Space Debris Mitigation Design and Operational Manual for Launch Vehicle Stages. So that is a standard that talks about how you mitigate against debris creation in launch vehicles with separating stages, because the physics of and the engineering of it is there will be the risk of bits falling off as stages separate. So how do you reduce the risk of creating debris in that situation? Well, you can look to these standards. And then similarly, there's this very broad standard, the Space Systems Space Debris Mitigation Requirements, which are a bit higher level, but talk about broadly what steps industry bodies should be taking to regulate debris creation. And then also individual governments can have their own requirements. So the US government orbital debris mitigation standard practices the responsibility of NASA, and they effectively guide how the US government develops its activities and focuses its activities when it comes to complying with debris mitigation requirements. So none of these documents are binding in and of themselves. They're given force effectively through their adoption and through through parties' ongoing reliance on them. So I might look to the ISO standards as a way of designing my launch vehicle or designing my satellite, and that effectively means that standard is relevant and has an impact because I'm doing it as an impacted person. Another really important one is political agreements and arrangements. So intergovernmental arrangements sometimes are less than binding. It might seem strange, but they're generally political commitments between different countries at different points in time. And the primary example of this is the Artemis Accords. So as you might be aware, the Artemis Accords are led by the United States. They were first created in October 2020 and had about 8 parties, I think it was at the time. And as of May this year, there now has 55 parties to it. Importantly, this is not a binding treaty. If a state decides to breach the content of that arrangement, there are no consequences. There might be political consequences. That state will be kicked out of the Artemis program, but there are no legal consequences arising from it. But importantly, what this agreement does, or this arrangement does, is set out a series of principles from which other states will adhere when thinking about space activities. So that refers to space debris and ensuring that the activities mitigate the risk of debris creation. It talks about the deconfliction of activities to ensure they're not going to cause collisions. They're not going to happen in a way that negatively impacts one another. But it also talks about the preservation of space heritage, that there are things in outer space that are worthy of preservation. In this particular example, that's referring mainly to the Apollo sites on the moon, because the US treats those as a form of space heritage, that they are placed on the moon and they should be there in an enduring and permanent manner, and no one should touch them or negatively handle them or destroy them, and they should be there for forever. Differently though, we also have guidelines and soft law. Here I'm talking about international guidelines, but there are also guidelines released by numerous other bodies across the world at different times. Any one day that anyone can really release guidelines or soft law or suggestions for certain practices. A recent and prominent example of guidelines are the guidelines for the long-term sustainability of outer space activities of the Committee of the Peaceful Uses of Outer Space. Now, these were developed by a consensus in the United Nations Committee on the Peaceful Uses of Outer Space mechanism, and they're developed as principles and recommend measures that states should take when thinking about the long-term sustainability of their activities. There are 21 guidelines overall, and the importance of this process is hard to understate because developing new requirements on states is nearly impossible from a political perspective. States are not necessarily willing to sign up to new treaties or new binding arrangements because of the geopolitical consequences of that and the limitations on actions. But the development of consensus standards in the United Nations mechanism is incredibly valuable. It means that no state actively opposed any of the principles adopted in that document. So they do actually reflect, to some extent, the general thinking of states when it comes to long-term sustainability. And so we can think about them not necessarily as law, but as strongly persuasive guidelines, effectively soft law, to how activities should be conducted now and the activities of states into the future. This document is directed at states, not at individuals or private actors, but it does contain messages about how states should be responding, and in turn, how private and individuals would have to respond under a fully implemented regime. So thematically, this document is really interesting. It covers policy and regulatory frameworks for space activities. It talks about the safety of space operations. It talks about international cooperation, capacity building, and awareness, but also scientific and technical research and development. All really important matters that need to be addressed when thinking about the long-term access to outer space as a domain. And just to highlight a few, these are the guidelines applicable to from a legal and policy perspective in that document. So here they're talking about states adopting, revising and amending national frameworks for outer space activities, that they should be considering a number of different elements when revising, amending or developing their laws, that there should be supervising activities conducted in outer space, that radio frequency spectrum is used in an equitable, rational and efficient way, and that we should be enhancing the practice of registering space objects. Now, why are these principles useful, important and necessary? Well, the first one is about establishing clear baselines of behaviour. Without national laws that apply to private entities, there is no clear baseline to move from. The next one is about developing and considering consistent and best practice requirements in those legal frameworks across jurisdictions to make sure that everyone's operating from the same base. So if we are thinking about sustainability, that everyone is thinking about sustainability and that everyone is obliged to act sustainably and with regard to the environment. But we are then supervising the activities of non-governmental entities in outer space, so they're not just free to do whatever they wish. There are still standards that apply. That radio spectrum is incredibly important, is a limited resource and it needs to be managed, because if we don't manage it, we'll lose access to our space assets. And enhancing the practice of registering space objects is actually about transparency and confidence building measures. That if we all know how we're acting in space and what we're doing in outer space, we're all going to be better for it because we'll know what someone else is doing and we can respond in kind to what they're doing to ensure we're not going to cause any issues and we can manage to deconflict different operations appropriately. Which takes me to a bit of a different concept, which is that of social license. It's kind of hard to formally define it, but effectively it's an idea of an activity that requires social permission of a population. That activities contrary to public interest should not be undertaken, and that activities reflect some sort of social conscience. So, am I carrying out an activity in a way that everyone allows me to do and that I have permission as an individual to carry out? So I'm not negatively impacting society on the whole. I'm thinking about the consequences of my actions. I'm thinking about the consequences and how to remediate any negative ones that can't be avoided. And I'm doing so in a way that's conscientious and everyone is willing to accept. Now, this is more of a concept that's been seen probably particularly in the West in the last maybe 5 years or so, but the idea that the consequences of acting without social license, particularly for corporate entities, leads to ideas around deplatforming, consumer boycotts, and reputational damage. That if you're a business that's not acting in the interest of everyone, the consequences are the people will leave you behind. That you will no longer be able to generate a profit, you will not be able to act in a continuing way, and therefore you will suffer the consequences. Why is this relevant to space? Well, if a private entity were to go into orbit and do something that offended social conscience, well, maybe as a consequence, we would boycott that activity. There would be significant reputational damage to that business. There might be deplatforming, which effectively leads to that business losing sustainable operations. It's no longer financially viable, it might not have customers to look for, and the consequences of its actions are not legal, they're not government-based, but they come from this social, this place of social conscience effectively. It's a bit of a harder one to define, but it's a really important advisory thing from many businesses now, particularly in the context of increasing importance of ESG systems, so environment, social and governance concepts when you bring them into large businesses to make sure that they are considering the consequences of their actions. I just want to quickly address the idea of private law as well. So contractual arrangements are incredibly popular in the private sector, of course. It's important to detail what you're doing, how you're doing it, and how you're dealing with other businesses. But of course, contracts can go more than just procuring a satellite. They can talk about more than me behaving in a certain way or providing a service. They can set the standards for the behaviors involved in that. So for example, it's really common now to see satellite manufacturers obliged to produce their satellites in compliance with a particular industry standard or a particular standard related to debris mitigation. So my contract might say, if I'm building a satellite, that I have to comply with the Interagency Debris Coordination Committee's requirements on debris mitigation. And if I don't do that, I'll be in breach of contract. Why is that important? Well, it's setting that, again, that minimum baseline when it comes to environmental consideration and sustainable considerations. Similarly, there might be requirements around conjunction risks. So operators of a satellite might not be the owners of the satellite. That operator might be required to consider space traffic management. They might be required to think about how close they are to other satellites and how they're managing the risks of collision. And all of these things might be preconditions to financial reward. If I don't tick X, Y, and Z, I won't get paid. I'm more likely to tick those boxes if I'm going to get paid for it. And at the same time, there are also the risks of non-compliance leading to litigation, to damages and financial awards as well that are quite detrimental. So there are a lot of different things you can put in contracts and a lot of different ways you can think about environment and sustainability when bringing them into the space sector from an environmental perspective. So that was a very quick introduction to the three broad areas I wanted to talk about from a legal tools perspective: the idea of international law, domestic law, and non-binding instruments or non-legislative instruments. And so now I'll turn very quickly to some of the limitations and then applying them to some of those challenges I introduced at the beginning. So, as we might know, international law doesn't necessarily solve everyone's problems. International law is commonly described as vague and not specific. It is very difficult to actively enforce, and geopolitical tensions and limitations can really hamper the content of that international law. Unfortunately, it's very difficult to say if someone was to do something in space that is utterly internationally unlawful, how do you enforce it? There is no mandatory submission to the International Court of Justice in the international space law framework. There is no mandatory enforcement mechanisms, so it becomes quite difficult to enforce. Domestic law, on the other hand, that's very jurisdictional specific. So the law here in Australia is different to the law in New Zealand, is different to the law in India, is different to the law in the United Kingdom. Every country has a different law and they'll apply in different ways. The content of those laws will vary significantly as well, which leads to this idea of a race to the bottom. Why would a business want to set up here in Australia if my standards are harsher than the standards in Japan? With significant ability to just move funds and people around the world now, if my standards are too high in Australia, they'll go to a jurisdiction with lesser standards, which can effectively lead to this idea of a race to the bottom, where countries remove standards and remove requirements to remove the burden on businesses and to make them easier, to make it easier to comply with. That can lead effectively to a lack of uniformity and the removal of barriers that will have negative consequences if not adhered to. And then when it comes to non-binding instruments, we're talking about this optional adherence. I don't have to if I don't want to. Why should I listen to someone if it's not going to cause a consequence? Why should I comply with that law if the police are not going to tap me on the shoulder for doing the wrong thing? So there's no enforcement, and there's only limited private enforcement. There's limited normative value in some of these instruments. And again, geopolitical tensions and limitations can effectively hamper or limit the enforcement of them. So now think about how we can apply these concepts to the challenges, the environmental and sustainability challenges I introduced earlier. So how can we apply the laws to the increases in space debris? Can we use these laws from an environment and sustainability perspective to address congestion in highly valuable orbital regions? What does it mean for light pollution, for example? How do we deal with increasing amounts of atmospheric pollution? And what is the possibility of managing interplanetary contamination beyond the Earth? So there's a lot that can be discussed here, and I'm going to go very much at a high level because these are all individual presentations of a week within themselves. So I thought I'd start with debris because I think most of us will be relatively aware of what space debris is and the risks that come with it. So now as a global community, we have an incredibly high awareness of space debris. We know what it is and we know what the consequences of not managing it are. And that is the Kessler syndrome. That idea that if you have so much debris in outer space, what will eventually happen is a piece of debris will hit another piece of debris, you'll end up with 3. That 3 will hit another 3 pieces of debris and become 9 or 12. I'm not great at maths, unfortunately. And it will exponentially grow and grow and grow, and we'll no longer be able to access outer space. That is not what we want. Humanity is incredibly reliant now on space technologies for connectivity, for enabling activities, for effectively everything across the board. So how does that reflect in our law? Well, at international law, there's no clear binding obligation to mitigate debris. What we have is due regard as the principle of international legal obligation, which is not really a legal obligation. It's just to have consideration to think about. National laws in different countries now do generally require some form of debris mitigation consideration. A lot of them will think about, well, you must have adhered to a particular industry standard or a recognized standard elsewhere. And then some jurisdictions are kind of taking the next step forward. So it's generally accepted now that space objects should deorbit within 25 years of the end of their life. But some jurisdictions are taking another step to go a bit harsher. The United States, a couple of years ago, introduced the idea of a quicker deorbit requirement. So I think it was 5 years for satellites that had a life who were below 500 kilometers. So you must bring it back within 5 years of the end of that operation. And that's a significant step up and significantly more difficult than many other existing standards had already required. The long-term sustainability guidelines, of course, recommend debris mitigation practices and effectively require states to take some steps or another. And then there are also non-binding agreements in place and arrangements. So a really important one of those is the memorandum on, the moratorium, I should say, on anti-satellite missile testing that a few states have unilaterally signed up to. So that one was very important because one of the largest generators of space debris is missile testing. And when there is a large missile tested, it creates a lot of debris, which can lead to significant more debris as a consequence. And so some states have voluntarily and unilaterally said, we are no longer going to test these technologies. We're not going to stop building them, but we're just not going to test them anymore because of the consequences of that. Of course, there is the debris mitigation requirement as well contained within the Artemis Accords. From a slightly different perspective, there's also the orbital overcrowding issue. So some orbits have greater utility than others and are therefore more popular. A brilliant example of this is the geostationary orbit. So the graph that should be on the screen on the left side is about the amount of objects that are in geostationary orbit. So the red bar is actually the mass of objects overall that have been placed in geostationary orbit over time. And as you can see, that has quite consistently increased. But there are some other satellites that are in different orbits that have also reached geostationary ring, and these present a risk to those main communication satellites in place. Similarly, the graph on the right is about payload traffic into the region of low Earth orbit between 200 kilometers and 1750 kilometers. And as you can see, the number of commercial satellites in that range has rapidly increased. And I wouldn't even call that exponential, it's just something a lot more. And what is that a consequence of? That's a consequence of mega constellations. When we deploy tens of thousands of satellites into really particular orbits, this is what happens. We get more and more there. We haven't yet reached the point where our orbits are overcrowded. But when you put more and more objects into space, the consequences you start to think about it's very much like traffic on the road. If you build a highway with 3 lanes, that's fine. Traffic will eventually build up though, and you're no longer be able to take any more. Unfortunately, in space, you can't add another 3 lanes. You only have so much space around the Earth, and the more and more objects you put into play, the more and more congested those regions will be, and therefore it leads to higher chances of collisions. A consequence of our international framework, though, is there are limited recourses and limited rights here. So what does due regard say? Well, it says I need to have consideration to others, but it doesn't say I need to factor in and think about others and to allow them to do things. There are liability-based consequences. So if these mega constellations were to lead to a significant debris event, there are financial consequences. But at the moment, they're so far remote and removed, we're not really thinking about them too much. So where does that leave us? Well, it leaves us with a few options. Are formal international agreements likely? No. We haven't yet seen any states really have any appetite for new international agreements related to space. Getting states to agree on anything is nearly impossible, so we won't likely see anything on that. Are political arrangements on orbital coordination possible? Yes, I think that's more likely. But the problem is it'll likely be with ideologically aligned states. So states that share a common goal and a common interest will likely coordinate with each other, which leads to potential for fragmentation and different approaches. Are guidelines and non-binding recommendations appropriate? Yes, they're probably a useful tool for coordinating between states. They effectively create a de facto baseline without states being legally obliged to adhere to them. An interesting one, though, is private law coordination appropriate? Some would say no, but in reality, we have actually seen it already. So in the last 3 or 4 years, NASA has entered into agreements with SpaceX and another US satellite operator, Planet, and effectively that agreement requires both SpaceX and Planet to give way to NASA rocket satellites and rockets if they're in the way. So if you picture it like this, you have the Hubble Space Telescope in low Earth orbit, and if a SpaceX satellite is on a potential collision course with that Hubble telescope, what will happen is the SpaceX one will move. NASA has said, we will not move. It is your job to give way to us. That's what we're contractually agreeing between us. And it's a really interesting private law agreement because the parties have effectively said to each other, well, we acknowledge there's a risk of collisions, and our way of mitigating that is to agree who's going to give way in what circumstances. But the problem with this approach is if you have an individual agreement between every company and every individual country, you've suddenly got 200 agreements about who's giving way to what, and you need to do that 200 times. For every single operator of a satellite, you end up in a situation of you actually don't know who's giving way to who anymore because there are so many competing contracts and arrangements. So it's okay at the moment with 1 or 2 large satellite operators, with 1 or 2 significant other operators, but it's not a solution to the future. Unfortunately, on this one, there's no clear path in our existing frameworks for clear orbital allocation outside of the International Telecommunication Union's arrangements for geostationary satellites. So I don't have the answers here, unfortunately, and as an international community, we have to look to that and what could possibly be the solutions. Light pollution is an interesting one because it didn't really surface as a potential consequence of space activities until quite recently. So this is effectively the consequence of light reflecting off of satellites and impacting people on the ground. So ever since Starlink became a major constellation, it's been somewhat common now to see the trains of dots across the sky following a launch like that on the picture on the slide. The consequence of these deployment trains are effectively they actually impact negatively on astronomy activities on the ground. So if you've got your telescope pointed into space, looking at something thousands of light years away, and all of a sudden a bright light skims right across the middle of it, the observations are no longer useful because they've been interfered with by satellites. On the other side of it, a lot of cultures put quite a lot of significance on the night sky and the stories and the learnings from the night sky. If you suddenly have tens of thousands of satellites interfering with that cultural connection with the sky, there is a risk of jeopardizing cultural enjoyment of outer space. And that's quite important for cultures. It's been a growing movement here in Australia with our Aboriginal cultures, as well as in Canada with the Indigenous populations there as well. But again, this is one where there's no clear legal path. So human rights and cultural protection laws might have some relevance. So we think about the International Covenant on Civil and Political Rights and the International Covenant on the Economic, Social and Cultural Rights. They do respect the rights of Indigenous groups, and they do respect the rights of every person to have and enjoy their cultural rights. But how do you enforce that in the context of the benefits that come from these satellite constellations? It's been described as a bit of a paradox because a lot of those cultures and communities that place quite a lot of significance in the night sky are also significant beneficiaries of increased communications capabilities. So they were normally in remote areas. They weren't previously able to get access to the internet or to communicate. So suddenly they're having access to satellite communications technologies, but it's coming at the cost of part of their culture and about part of their connections to their culture. National laws can have a limited scope to actually apply here because most of the time they're about communications. They're not about the launch of those objects in the first place. Generally, only one country will have jurisdiction and control over the satellites that are in outer space. So far, we're seeing voluntary measures prevail. So what is a state willing to do itself? What is a company willing to do itself to remove or reduce the amount of light reflected back? And it's a voluntary thing, effectively coming out of the idea of social license. That when these trains of satellites started first appearing in the sky, there was a lot of media coverage and a lot of negative media coverage about the consequences of them and what that might mean, which effectively led to pressure on operators to think about how they reduce their impact on the night sky. So there are a couple of different layers there, but we don't yet have a legally binding option to fix this situation. An interesting one that's appeared more recently is the risk of atmospheric pollution. So our gold standard of debris mitigation is bring things back to Earth. Burn satellites up in the atmosphere so they're no longer in orbit and not causing a problem in orbit. What we've now realized is the more things we bring back to Earth and burn up in the atmosphere, those metals, those chemicals don't just disappear. They evaporate, they are effectively destroyed or burnt up in the atmosphere and particleized in the atmosphere, but they then remain in our atmosphere. So there has been increasing recognition now that we're depositing heavy metals and other heavy chemicals into our upper and mid atmosphere as we're burning satellites up, which presents a significant challenge for the conventional practice of deorbiting satellites. And this graph here from that European Space Agency report shows that we are now, as a consequence of mega constellations, bringing back a lot more objects than we ever have before. And that's merely a consequence of having more satellites. They need to come back. Businesses are acting in a responsible way by bringing them back. But now we have a new consequence. We're now depositing pollutants into our atmosphere differently than we were before, which it's not on the slide, but it's quite an interesting issue because rocket launches look like they're significantly polluting events. They release a lot of chemicals and a lot of debris when they launch, but in most cases, if you're launching an imaging satellite to take photos of the ground, after I think it is about 3 days of that satellite being in orbit, it has broken even effectively on the climate impact of using aircraft to take the same type of images. So space activities are climate beneficial, but there are now these new issues we're seeing. So how do we deal with that? Well, not really sure just yet. We have to track the development of debris mitigation guidelines and look at how things are progressing. So do debris mitigation requirements now need to start including requirements on how or what objects are capable of being made of? Can they have to do certain chemicals that stay in the atmosphere longer and cause significant more harm need to be removed from spacecraft composition? Do we need new standards for debris mitigation? Should we be sending stuff out into space indefinitely? That requires a lot of energy. It requires a lot of fuel. Will we be looking at new types of social license or self-regulation in this space? And are there different opportunities into the future? And again, this is a very, very new issue we've had and one that's only really been picked up in the last couple of years. But I expect this one to be quite important, particularly as space becomes more and more normal and we bring back more and more objects through the atmosphere. And finally, interplanetary pollution is not something we have to think about too much just yet. But it does become an emerging risk as we send more and more things and people deeper into outer space and onto other celestial bodies. We think about the environments here on Earth that humans have occupied that had never been occupied before, and we tend to bring pollutants with us. We tend to bring rubbish. We tend to bring our humanity with us and think about the consequences of that later. So the Outer Space Treaty, as I said, protects the Earth from contamination from space, but what are we doing to protect space from us? And so the Moon Agreement contains provisions that are not well accepted. The Artemis Accords purports to protect aspects of celestial bodies as well, but we really look here in the case to the COSPAR policy on planetary protection, which most scientific agencies adhere to because it includes requirements about making sure there aren't bacterial contaminants and there aren't other contaminants on spacecraft visiting objects in outer space. So that one's quite important and one that non-binding standards are currently the leader for. And I'd expect those to become more and more important over time as well. So that brings me to the conclusion, which effectively is the space environment is at risk from increasing human activities. And there's a need to balance the sustainability of space activities with sustainability of the environment itself. So we need more satellites in space. We need more things in space to make them commercially viable and commercially sustainable. But we also then need to think about the flip side. How are we making the things sustainable for the environment itself? We have various levers that exist to address the challenges, but effectiveness will, of course, vary over time as well. And so that's the end of my presentation. Of course, I'm happy to accept any questions you might have from those watching along in the chat or or otherwise. I can see there's some queries about the PowerPoint, and I will send it to the team at the Legal Vision, Voice, sorry, as well. So hopefully you can receive that from them. But in the interim, does anyone have any questions?
Astha, you can go ahead.
Good afternoon. I have a question with respect to satellite burning just after the launch. So recently there was case of SpaceX and many other satellites that just burn after the launching of it. So how do we trace the liability, or even how do we trace any law with respect to that?
Yeah, so if I understand correctly, it's a question effectively of satellites coming back very quickly after being launched, and how we manage that. So operators like SpaceX put a lot of effort into making sure that they know how to return objects at any point in their operational life. There was a brilliant example recently of a launch, that was impacted by a solar flare. So a whole train of SpaceX Starlink satellites were never able to reach their operational orbit. They came back to Earth a lot quicker than expected, but it all followed a very particular debris mitigation plan, in the sense that they realized very early on after deployment they weren't going to operate and were going to come back and burn through the atmosphere. The liability point, though, is always quite interesting, because if we are, generally things will burn up in the atmosphere. We won't see them on the ground. If they were to cause long-term problems from burning up in the atmosphere and increase pollutants, well, how can we prove who did what? And that's the problem we have, because fault is generally the conditional liability, which means it's very, very hard from a legal perspective to identify an individual entity or countries, for example, that are financially or should be financially liable. So I unfortunately don't have a firm answer for you on it, but it is one that becomes this lovely mix of effectively good behaviours, adherence to positive debris mitigation standards and guidelines, and respecting the need to protect the environment in one way or another.
Just to follow up, if we consider that the satellite has been burst before reaching an orbit, which is after the Kármán line, so how do we trace the liability? I mean, it has not technically gone into the space, but it is somewhere in the atmosphere. Does the aviation law come into the picture, or is it the space laws that come into picture?
Okay, so if a satellite was to not reach outer space and cause damage on the ground, the liability convention apportions liability on an absolute basis. So if I were to launch a satellite, it doesn't reach orbit, but it crashes into the next country over, my country is financially liable for that action, no matter what, because the provisions of the liability convention, I think it's Article 3, are that damage by a space object on Earth or to aircraft in flight is absolute. So it applies to the operator state, and then the state will then seek out the individual operator after that. So it's deemed on an absolute basis on the ground or to aircraft, and then fault-based in outer space.
Thank you. That answers my question.
Sorry, who is next?
Kaushal, you can open your mic.
Good evening. Good afternoon, sir. Actually, I wanted to ask whether we all know that the definition of environment is something which cannot be defined. As you know, we also studied yesterday also and today that there are many treaties talking about the environment. But can another legal instrument like UN is taking consensus or any other national legislation of any country can be helpful for defining environment of and environment and sustainability in space law?
Yes,
Can
most
it be
certainly.
done?
So I think states can take states. Of course, we have different levels of different levels of law. Of course, we have our international customary law, which is developed by states, developing and adhering to certain concepts and principles over time, and developing norms of essentially of behaviour as well as legal norms. If states started introducing definitions of environment and space sustainability into their national legal frameworks, and arguably they start to say that we're obliged to do this, and that's why we have. It starts to create these legal norms and these legal obligations and the potential for effectively internationally agreed approaches to sustainability environment. importantly, the long-term sustainability goals were an amazing achievement by the UN COPUOS. And it does, again, represent another pathway that the UN body might take to try and develop key, clear definitions. But I would say at the same time, while the lawyer in me loves clear definitions, like I think those of you who are practicing might understand, like, a clear legislative approach is amazing, but at the same time, ambiguity is really important for long-term application, and spreading and changing the definition of things over time. Ambiguity can be good. And so sometimes, like how we don't define where outer space officially starts for international law, that can be quite helpful because it means we can adapt things to new circumstances.
Thank you, sir.
Hello, I'm Dhruv. My question is regarding a slide which you presented. Every countries are coming up with their national legislation on space, and now the tax regimes are changing. Certain other laws are applicable. So now, in case of a failure of the space applications or the projects employed by the private actors or the state actors, so what do you think about the space insurance field?
Space insurance is a really important and growing field. It's one that I think it's an interesting one because I think it actually creates standards of behavior as a consequence of how it operates. So the space insurance market is essential to the operation of the commercial space sector. I've worked with clients previously who their activities and their risk profile will change depending on what insurers come back with and say. So if an insurer says, if you make an application for an insurance and the insurer comes back and says that's not acceptable for us for these reasons, or puts a ridiculously high premium on it, operators will change their behavior to make it cheaper, to make it more acceptable. And it becomes quite important then for how the insurance market is shaping behaviors in the space sector. And it's only growing, I think. So we see the space policies generally, they're kind of generated out to farmed out to a lot of different insurers. So they'll collectively insure together. And the insurance market is becoming larger and larger as we appreciate the risk. At the same time, though, significant events like an explosion on a pad or a large failure on orbit can cost significant amounts of monies to underwriters, and that sees them exit relatively quickly when they have to pay something out. But it's a really important market. I can imagine it's one that's only going to grow in importance in the coming future.
Thank you so much. That answers my question.
You're welcome.
Ajay, you can speak next.
Thank you, sir. So my question is pertaining to commercialization of space in terms of space mining and utilization of space resources. So the question is whether existing space treaties allow exploitation of space resources when the already established norm is non-appropriation of outer space and celestial bodies in that sense. And another question in supplementary to that is, what do you think whether space resource utilization can be done in sustainable manner, or we are going to face tragedy of commons in outer space? Thank you, sir.
Difficult question, and one that really makes the international community very scared. I think whether it's allowed or not comes down to national perspectives. A lot of countries will take the view that taking the resources from a celestial body is not taking the celestial body. I think that was used as the justification from Luxembourg when he introduced its laws allowing resource exploitation. That effectively, they use the analogy, well, fishing in the high sea is not appropriating the high sea. So why is taking resources from the moon making it appropriating the moon? It can't be, it's different. So it's an interesting one. I think I'm a bit more on edge. I think the idea is in situ resource exploitations, the idea of using the resources that we have in place in outer space for the furtherance of a particular activity, I think is perfectly reasonable. So using water ice on the moon to further future uses of the moon, uses on the moon exploration activities is reasonable. The commercial side of things, I'm not sure so much. It's a bit of a harder exercise because it comes down to commercial profit, which does tend to conflict a little bit with the core concepts of the treaty frameworks around benefits to all. But I don't think it's a framework that a problem that can't be overcome. So the Moon Agreement, for example, contains the baseline provisions on allowing resource exploitation in space. There's work being done at the UN level consistently on enabling space resource activities to occur. And I think there was a recent announcement, I'm sorry I'm not across it, at a recent session of the Committee on the Peaceful Uses of Outer Space on this point. So I think it's potentially there and it's going to happen. On the sustainability side of things, I am not completely sure. I think we'll probably take more steps to protect the sustainability side of things for resource exploitations in space, more than we have on the ground. I think it's fair to say a lot of businesses, a lot of mining companies have learnt their lessons on the ground, and we hope that we take those lessons with us into space. Of course, I'm sticking that still on hope, that I hope we carry the lessons we've learnt on the ground into space with us and don't leave them here on the ground.
Thanks a lot, sir. Thank you, sir.
Tawfiq?
Hello, sir. Good afternoon. My question was regarding exchange of, resources, like intellectual resources, like information we obtain about galactic bodies or their behaviors. I wanted to know, is there any legal instrument which regulate the exchange of information, or is there any obligation to share crucial information between two states, and what governs that?
Yeah, that's an interesting one. So the Outer Space Treaty and a few of the other treaties do encourage scientific collaboration. So they encourage the sharing of information developed and received between states. It's not a firm obligation though, so it's not a mandatory, which leads, of course, to states withholding information when it's personally beneficial to them. And in the scientific community, of course, you withhold information prior to publication and release of that information. So there are two sides to it. We should be sharing information in as much as possible. It's a good idea to share information, but at the same time, we have that problem. We also have geopolitical tensions, effectively, where certain states might not want to share certain information because it'll benefit another state and it will just destroy their competitive advantage. So we don't have any mandatory obligations. We have the encouragement to share information, but that doesn't always happen.
And also one more question, sir. Should we divide the space territories like we have divided the oceans for better, governance and all that?
I don't think so. I think we keep it open for everyone, because as we push boundaries out, setting boundaries is a relatively dangerous thing to be doing. We see it in border regions across the world where boundaries are not firmly set in place. They generally lead to conflict, and I think the de facto position that there are no boundaries are effectively the boundaries. So no one can make a grab, and if they are, that's where it becomes unlawful.
Okay. Thank you, sir. That answers my question.
Tanisha, you're next. I think, sir, Tanisha posted her question in the chat box, so if you can please take it up.
Yeah, I'll have a look at ones in the chat now. Actually, I'll go through them in the order. Whether there are existing treaties that allow such exploitation of resources when non-appropriation is one of the principles. The Moon Agreement theoretically allows resource exploitation, but the provisions are not yet properly enacted. And because so many states don't adhere to them, don't accept the Moon Agreement as a treaty, that's unfortunately left many of them to ignore that and not really make it operational. So there's no exploitation provisions yet. Do I think that outer space resources can be explored and used in a sustainable manner? Yes, I think we can do it in a sustainable manner. There are ways and controls we can put in place, but it's a question of how we do it and whether we do it properly. I think as a humanity, we tend to not learn from our mistakes, but I can hope that we do when we look to the space domain. Number 3 here, do you think the tragedy of the commons will take place in outer space? I think the answer to the last one kind of leads to that I think there's a risk of it, but we can cross our fingers and hope we learn not to. What's this last one? So my question is that, do we as a world really need to strike a balance between growth, development of outer space activities, and preservation, protection of the environment? Yes, I think we need to be thinking about the nature of our activities and how we do them and why we do them as well. I'm not an engineer, so I can't speak to the limitations of the engineering, but of course, there are limitations and there are barriers, and that leads us to develop lots of satellites and lots of technologies. But I'm going to use the line from that lovely movie, Jurassic Park, and say, just because we can, should we? Because sometimes it's not ideal. When I mentioned light pollution, could satellite operators schedule launches such that they avoid critical astronomical observation periods to reduce research disruptions? That's a hard one because it's not necessarily the launches that are causing the disruptions. It's actually just the satellites that are in orbit regularly. So they could schedule them, and they do need to schedule them, but sometimes it's quite difficult to do so. But no, unfortunately, it won't be beneficial overall to astronomical research because it's the satellites already in orbit that are the problem. So, thanks for going through those. I'll jump back now.
Good afternoon, sir. This is the last question I'm asking. What if there is a data after collection the debris and there will be a more litigation process in this, like between the countries? What will happen?
Sorry, can you repeat that?
When we collect the debris, we'll collect also the data of other countries. So after that, they can claim for the data, and we will go for the more litigation process in this, like between the countries and all.
Yeah, so reclamation of debris and taking debris is a bit of a contentious area because, of course, once a satellite's no longer operational, it's hard to declare who is the owner of it unless it's got it stamped on it, and recovering that is also incredibly difficult. So it would be a contentious matter. I can't point to any particular legal framework at the moment, but a state would say that it's an unlawful interference with their space object. Another state would say that, or is it yours because it doesn't operate anymore? And it would likely cause a circle of complaints. And unfortunately, that's why we don't. Generally, it's one of the contentious issues around active debris removal at the moment. So hopefully that answers that question.
So data protection also comes into the picture after collecting the debris, maybe.
Sorry, do you repeat that again?
So data protection law also comes into the picture after collecting the debris.
Oh, it depends on the content of the satellite and what's being collected.
Okay, sir.
Yeah.
Thank you. Thank you.
Just to the next question I've got is Catalina.
Yes, hi. How are you?
Good, thank you.
So, you probably have mentioned some of the things that I want to ask. So I understand there are certain prohibitions or concerns regarding to the sending of biological material, such as human ashes or biological samples into outer space. Who is responsible for regulating such activities? Moreover, how are symbolic or recreational actions in space legally addressed, particularly regarding their potential impact in outer space or any element that re-enters and falls back to Earth? I've heard that there are some companies that, send some human ashes just to make a turn as a symbolic thing. So that's the first thing. And the other question that I still don't get how it's gonna work. In what ways could mining activities on celestial bodies or the moon affect the natural functioning of the Earth? Will there be any kind of limits imposed on mineral exploitations, or how is it gonna work? Because as you mentioned, mining companies here in Earth, at some point you have a regulation, but they try to overexploit it. So how is gonna work? Because we are not gonna be able to 100% see outside. Those are the two questions I have. Thank you.
So on the first question, the release of biological materials in space is quite an interesting one, because theoretically, as I said, the Outer Space Treaty only protects the Earth. It doesn't protect outer space. And we've seen a few companies, as you said, like launch ashes and stuff into space as that symbolic gesture. Like, I'm not going to spread my ashes in the sea or in a park. I'm going to launch them into orbit to then just rain back down on the Earth. There was, I think, it was last year, there was a lot of contention around particular ashes launched to the moon. And I think I think it was Native American Indian groups had said that they were quite concerned with that because of their cultural connection to the moon and the role it plays, that it shouldn't have things like ashes launched to it and landing on the moon, because that violates their cultural connection with it and undermines their cultural significance there. Unfortunately, it comes down to individual states and how they respond. So we don't have any firm mechanisms there. There's nothing clear, unfortunately. The Coast Guard guidelines on planetary protection are only guidelines. They're not binding on anyone. If someone decides not to accept them, they don't accept them. And that's the downsides, of course, with standards and industry standards. And it's unfortunate that that's the case. But yeah, we're not. I don't have an answer for you, unfortunately, on the binding side of it. And the second question, that's a very hard question to answer. I think I don't know the answer. I think there's probably a scientific answer in there, that we shouldn't bring certain things back to Earth, because if we do, we might knock our own planet's equilibrium out of whack. You know, we have a certain amount of water on the planet. We have a certain amount of resources on the planet. We recover a little bit and gain a little bit every year through asteroids and meteorites that return to the Earth, or that come to the Earth, but it's not a material gain. And so there's a question there about, well, if we're bringing lots of resources back, are we actually impacting on the equilibrium that's established on the planet as it is? But unfortunately, I don't have the answer to that question.
Yeah, no worries. I was just actually thinking about the fact that many things on Earth function in order of the movement of the moon as well. So there's, I think, a cartoon or something that I saw some years ago that the moon has is aided somehow, to say somehow, like it has a hole. So that's why this question comes to my mind.
Yeah.
Like, how is it focused? But thank you very much.
You're welcome. Who was next?
Good afternoon, sir. Well, my question relates to the Artemis Accords and the national policies wherein non-legislative authorities like NASA and ISRO are making such policies. How binding is that, and how does that work?
Yeah, it's an interesting question. And to be honest, the default answer is they're not binding, and states are doing them because they agree to them. The Artemis Accords is a really interesting example and a leading example of this idea of interpretation and binding norms through subsequent state practice. So while it's not a binding agreement, it signals to the world how those individual states have interpreted their obligations at international law and what those obligations might actually mean. So entering into these politically non-binding agreements actually sets kind of a tone for the world around what things might mean and how they might be interpreted. So that's what the significance of these instruments are. So the Artemis Accords, interpreting the treaty provisions, say, yes, we can take resources on the moon. We need to have debris mitigation. You need to protect space heritage, are a way of effectively signaling to the world, these are the basic principles and norms we're accepting. Can we please accept them? So there's a lot that kind of feeds into that. They're highly effective in the sense that they're gathering consensus and they're building consensus between parties. They're not effective from a binding perspective, but that's not the actual goal. They're more of a political instrument to reach a conclusion. That is what we have with the Artemis program.
So we'll be taking one last question for the day and going chronologically. That would be Shrishti Singh.
Good afternoon, sir. Actually, I want to ask about, we know about Kessler syndrome, which was proposed by Johann Kessler. So in 2009, back in 2009, there was a collision between iridium-33 with the inactive cosmos. So at that time, so the iridium was an operational one. So which actually hindered the operation, it's a communication satellite. So it hinders the work. It basically, it's a very huge loss for the country as well, because of the satellite. So is there any law which governs this, and will the Russian satellite, Russia will be held liable for it?
Yeah, that's a very interesting one, because the situation presents a lot of competing issues. So there's a lot of narrative around that. So that situation happened, and there was no claim. There was no claim from Iridium. There was no claim from the United States. There was nothing in Russia. It kind of just happened, and then we forgot about it, or we left it alone. Why? Well, because no one could cleanly and obviously lock down responsibility and fault for that incident. So there is a suggestion that Iridium were told there is a risk of a collision coming. That risk is serious. You need to address it, Iridium. Iridium said they moved a bit, but did they move enough? Not necessarily. No, we don't know. The Cosmos satellite, of course, could not move. It was defunct. It was dead. Should it have been there? Well, by modern standards, no, it shouldn't have been there. By the standards at the time it was launched, is it okay to just leave stuff in space forever? Well, back then, effectively, that was the norm. People did leave stuff in outer space for a significant period of time. There are still satellites that were launched in the 50s and the 60s that are still orbiting the Earth and will be orbiting the Earth for another 200 years. So at the time, it wasn't a problem. Today, it would be unacceptable for Russia to leave a satellite there for that long that was doing nothing and not have a serious debris mitigation standard in place. But today, we also have a lot more accurate conjunction analysis and assessments. So there are multiple businesses, there are different governments on the ground that track all these space objects to a lot more precision than we did in 2009. And so there is a lot greater chance that we would avoid that now. But from a liability perspective, it's really, really difficult, because should an actively operating satellite be required to move out the way of one that doesn't work? Probably. Should the defunct satellite be there in the first place? Probably not. So who is the primarily responsible entity in that instance? Well, they're both at fault. So it would be a very difficult one to apportion liability completely for. And that is the biggest concern with the liability convention, of course, is it's hard to apportion fault when we're all in space together and we're all doing these things together.
Okay, thank you so much, sir.
Yeah, hello. Hello. Yeah, I'm audible.
Yeah.
Yeah, very good afternoon. I'm Advocate Sanjay here. And my question is related to definitely environmental protection and sustainability, which itself looks to me very contradicted. Now I'll come to the question. Yeah, am I audible, sir? Yeah. So my question comes now, like, as we know that moon is called as now occupied celestial body, and the next is definitely on the Mars. And the people, private entities like Elon Musk and everybody, you know, they are definitely trying their best to occupy whatever they can do it. At the same time, you can find out there are so few rogue nations are there who defy all the treaties and rules and regulation, and they do what they believe themselves that yes, it is good for them, and it may be a best for everybody, but it doesn't work in that way. Now, let's say the moon, as it is occupied nation, and everybody, you know, it becomes a lab for the whole all the nations, and they do all the you can say lab thing or anything without caring of the environmental or chemical or anything, and it becomes a launching pad to the other celestial bodies as well, right? So at the same time, we are saying that we are doing a lot of for the environmental protection, and at the same time we are talking about the sustainability, which doesn't go hand to hand, because if you want sustainability, you need to somewhere disarm those we are not following in Earth. So how do we follow on the moon as well? I don't understand that. So it's all about the only talkings, or there is definitely who will be responsible for these all, because all the nations are trying to get the best from there and nobody wants to take the responsibility of all these different things. So how it works and who is going to take the responsibility? Thank you.
Yeah, you've just described effectively the biggest problem, that we have the tragedy of the commons idea that space is for everyone and space should be for everyone. Therefore, everyone is responsible, and it is everyone's responsibility to look after it. But of course, when everyone is responsible and everyone should do the right thing, no one does. And everyone acts in their own self-interest, which causes harm to someone else, which causes harm down the track. So you've tapped on what is probably the biggest concern we have as a global community and how we address these things. It kind of falls back to the international rules-based order that we have treaty frameworks in place to try and alleviate these risks and harms, that the frameworks that exist theoretically set the basic guidelines for how activities should be carried out. But of course, the opportunities and the appetite to enforce are important. I can't forecast what, for example, the United States might do tomorrow. They seem to change their policy position on a lot of these things quite rapidly. So it's hard to see how they might approach the moon or how might approach Mars from an environmental perspective. At the same time, we've seen people like Elon Musk say he wants to make Mars habitable. So he wants to release several nuclear weapons on Mars to create an atmosphere. That's utter nonsense from an environmental protection perspective and sustainability perspective, because we should be preserving that environment for the environment that it is. But at the same time, well, who's going to stop him? The United States, if they feel like it. That's the jurisdiction. And if we, as a global community, don't find that acceptable, well, the global community then has to sanction the United States. So what you've effectively touched on is the biggest problem with space regulation, that we can do certain things. We all benefit from space. We can do certain things to implement rules and norms, but you do need to enforce them. And at the moment, they're enforced on the idea that if we don't all comply, we'll all suffer the consequences. So it's the collective benefit approach, that if one person does the wrong thing, it'll negatively harm on everyone else and themselves. And that's the kind of the teetering edge we're on. All it takes is one state to act in their own self-interest to everyone's detriment, and it all just falls apart. But that's effectively how our international legal system works, generally anyway. So I don't have all the answers on that one for you, because it is such a vexed and complex question.
That's fine. Thank you.
Since it's evening in Australia, very good evening, sir. My question is similar what was asked to you. Since you mentioned the increasing role of the private actor and the gaps in the binding international law, so do you see any scope for creating a space-specific environmental impact assessment framework similar to what is done under the domestic environmental laws on Earth that could be applied to the mega constellations or the solar lunar emissions before the launch approval?
Yes, that depends on an individual national frameworks. So some frameworks do require environmental impact assessments to be done. The United States has a form of that through the National Environmental Protection Act. Australia requires environmental impact assessments for launches, but not for activities in space. Some European countries require some consideration of the environment and sustainability, but there are no formal requirements. I've seen proposals for environmental impact statements on a template basis several times, but it's just a matter of a country or a state accepting that. So I think we've got potential there, and it's a good idea, and it's one that probably will be seen more and more into the future, as we need to balance the interests of an activity and it being done against the consequences of that activity. It's just a matter of an appetite for that from a regulatory perspective, which I'm not sure is 100% there just yet, because as you might guess, most commercial actors would seek the lowest regulatory burden possible. We don't want to do things that we're being forced to do unless we desperately have to, and we need to make them as efficient as possible. And additional environmental impact assessments and statements are not necessarily in the spirit of that. So it would take a bold regulator to force it on anyone, but I think it's a good idea, and one we probably need to think about in the future, especially in the context of the last question, where every state, every person, every state's acting in their own self-interest, and we need to think about the consequences of that.
So we won't be able to take any more questions now. I don't think we're left with that much time. So anyways, thank you so much, sir, for joining us here today, and loved your lucid insights, and hoping on collaborating with you further and Flinders University in the future. So thank you so much, sir.
Okay, thank you.
For today, and for the participants, please do join in at 3 p.m. Indian Standard Time for the next session. Okay. Thank you, Joel, sir.